Good morning, everyone, and welcome to this edition of the Senate Committee on Commerce and Labor for the 81st Legislative Session. Madam Secretary, please call the roll.
Senator Hardy, Senator Lang, Senator Neal, Senator Pickard,
Here.
Senator Scheibel, Senator Settlemeyer, Chair Spearman.
Thank you, and please note that I believe we have everyone present. And with that, also want to welcome the audience that's joining us remotely and anyone listening over the internet. Today we have hearings on Assembly Bills 222, 436, 442, and work session on Assembly Bills 4, 18, 45, and 437. I'm going to take a moment to go over some housekeeping items, and I know I say this all the time, and some may think, well, why don't we just get on? But sometimes we have new people, and they may not know, so I need to make sure that everyone knows the rules of the road before we get started. The legislative building is open to the public under certain restrictions. And therefore, there are some presenters and some people in the audience and some committee members who will be working and testifying remotely. They'll be conducted through Zoom, video conference, or by telephone. There are various ways that you, the members of the public, can engage with us and participate throughout this process. You can register to participate on Nellis, and you'll have an opportunity to testify on a bill or request to join the meeting in person. To provide comments, you can submit your written comments to the committee email address or fax number that's listed on the agenda. You can also share your opinion via the legislature's opinion application on Nellis, or you can view the committee meetings online through Nellis or on the legislature's YouTube channel. To register on Nellis, simply click the Participate button, and they'll ask you for some information, your name, telephone number, the bill number, what you'd like to do. And once you submit all that, then you'll get another email that will give you the information in terms of the time, the date the bill will be heard, and also give you information as to how you can dial in or a Zoom link to testify. If you request to participate in person, you will receive all of these things via email. But remember that even though you sign up, because of time constraints, we may not be able to get everyone on for the comments. And just want to note that this is really not different than what we would have to do were we in person. There's only a certain amount of time that we have to occupy this space. So we've got to make sure that we get done what we need to get done and make room for others who might be waiting. If you are testifying, also want to make sure that you understand that if you testify and say something or you give something information that is, that is not factual, then it is a misdemeanor, and any member of this committee or the chair can call and ask for you to submit documentation to support your testimony, and that's pursuant to NRS 218E.085. Committee members, if you're virtual and have a question, please raise your hand through the Zoom application. If you are present in the room, then please make sure that you unmute your mic and let me know that you have a question or would like to make a comment. And if you raise your hand via the Zoom application, this is what your screen will look like. So with that, why don't we get started with our very first bill. And one more thing, make sure that you mute your telephones, your laptops, and anything else that will go ding in the night. Anything that sounds like fruit, apple, blueberry, anything that sounds like you're on a ski trip in Colorado, anything that's going to go make noise during the during the hearing, please make sure that you mute it so as not to disturb those who are testifying. Or those who are trying to listen. And also want to make sure, I've had an opportunity to listen to our meetings, to not just our meetings, but to several committee meetings on the YouTube channel and online. If you're not projecting your voice, it will be very difficult for people who are trying to listen to hear what you are saying. And it's very unfair if they have taken the time to tune in, if we don't take the time and make the effort to speak loud enough, project our voice, and speak clearly enough so that they can hear. And that goes to not only committee members, but also to those who are presenting. Would request that you adjust your microphones now and your position or your proximity to the microphone so that you are speaking not in your outside voice, but don't use the whisper, okay? And so with that, let's get started. I want to begin the work session first on Assembly Bill 4. Mr. Melgarejo, please walk us through the bill.
Thank you, Madam Chair. For the record, Cesar Melgarejo, Committee Policy Analyst. Our first bill is Assembly Bill 4. Is sponsored by the Assembly Committee on Commerce and Labor on behalf of Division of Insurance and Department of Business and Industry, and it was heard on April 28, 2021. Assembly Bill 4 makes various changes concerning the Nevada Insurance Guarantee Association. Among other things, the bill limits the claims that may be asserted against a person injured by a policy issued by an insolvent insurer, adds various types of insurance products designed to protect the interest of a creditor arising out of a creditor-debtor transaction to the types of insurance that are not covered by a guarantee association, and describes certain coverages under the warranties and service contracts that are not covered by a guarantee association, amends the types of claims that are covered by a guarantee association, extends the claims filing deadline from 18 months to 25 months, and lowers the net worth threshold for first-party claims, which are claims made by insureds, to $10 million, and changes the amount of the guarantee association's obligations to pay a covered claim by reducing the limit to $10,000 for each policy if the claim is for the return of unearned premiums, and clarifies that the guarantee association is not bound by unfunded settlements or releases that are executed or entered within 12 months before an order of liquidation, and there are no amendments to this measure.
Thank you. Committee members, are there any questions or comments?
Do pass.
Have a motion from Senator Settlemeyer do pass. Do I hear a second?
I'll second it.
I have a second from Senator Pickard. Any further discussion? Seeing none, and throughout this process during work sessions, we will be using a roll call to record the votes of each member. And so with that, Madam Secretary, please do a roll call for the vote count. Thank you.
Senator Hardy,
Yes.
Senator Lang, Senator Neal,
Yes.
Senator Pickard,
Yes.
Senator Scheibel,
Yes.
Senator Settlemeyer, Chair Spearman.
Yes. And so with that, let the record show that the motion carries. And I'm going to ask Senator Lang, will you take the floor statement on this?
Yes, Chair.
Thank you. Work session now on Assembly Bill 18. Mr. Melgarejo.
Thank you, Madam Chair. For the record, Cesar Melgarejo, Committee Policy Analyst. Assembly Bill 18, sponsored by Assembly Committee on Commerce and Labor on behalf of Division of Insurance of Department of Business and Industry, and was also heard on April 28, 2021. Assembly Bill 18 eliminates the limitation on the maximum amount of uninsured vehicle coverage that may be provided by a motor vehicle liability insurance policy. The bill provides that certain notice requirements do not apply to a policy upon renewal if the changes to the policy's provisions are favorable to the policyholder, and there are no amendments to this measure.
Thank you. Committee, further discussion? I'll entertain a motion.
Motion to do pass. Second.
I have a motion from our Vice Chair. Do I have a second?
Second. Senator Lang.
Second, huh?
Second, Senator
Oh,
Lang.
Okay, I got you. So we have a second motion by Vice Chair Neal, and we have a second from Senator Lang. Additional questions or discussions? Madam Secretary, please call the roll for the vote, please.
Senator Hardy,
Yes.
Senator Lang,
Yes.
Senator Pickard,
Yes.
Senator Neal,
Yes.
Senator Scheibel,
Yes.
Senator Settlemeyer, Chair Spearman.
Yes, and let the record show that the motion does carry. I'm going to ask Senator Pickard, will you take this for a floor statement, please?
Yes, ma'am.
Thank you, I appreciate it. And now we'll go to our work session on Assembly Bill 45. Mr. Melgarejo.
Thank you, Madam Chair. For the record, Cesar Melgarejo, Committee Policy Analyst. Our next bill is Assembly Bill 45, again sponsored by Assembly Committee on Commerce and Labor on behalf of the Division of Insurance of the Department of Business and Industry, and it was heard on April 28, 2021. Assembly Bill 45 makes various changes relating to insurance. Among other things, the measure revises provisions relating to bonds filed by various persons regulated by the Commissioner of Insurance, revises provisions governing the service of processes on certain insurers, and revises provisions governing the issuance, renewal, and expiration of various licenses, permits, certifications, and other authorizations to engage in an activity relating to insurance, provides specific requirements for certain stop-loss insurance policies and the insurers who issue them, revises certain requirements governing holding companies and reinsurers and reinsurance, expands the list of statutory provisions to which certain healthcare-related entities and risk retention groups are expressly made subject, and revises provisions governing annual disclosures by certain persons regulated by the Commissioner of Insurance. And Madam Chair, the sponsors have noted that there are no amendments to this measure.
Thank you. Committee members, questions, comments?
Madam Chair, this is Senator Settlemyre.
Yes. Senator Settlemyre, yes, sir.
I appreciated the amendments that were provided in that respect. I'm trying to find a way to try to help out some of the small self-insured groups. I believe that some of the regulations that are currently in practice are a little bit onerous on them, and that we could do a lot to try to help out these small businesses in that respect. Yeah, in that concept, I was wondering if there could be much discussion on the Second Amendment that I see in front of me. I think it is reasonable in that respect. So I was wondering if there was any discussion on that or how the rest of the committee felt about that.
Madam Chair, we do have the Commissioner of Insurance on Zoom that can answer any questions.
Yes, I was just getting ready to ask Commissioner Richardson, you care to respond, please? Or anyone else that you may have there that might be able to address these concerns?
Thank you very much, Madam Chair. So for the record, this is Barbara Richardson from the Department of Insurance. So the amendment that was provided, the Second Amendment, which I believe that Senator Settlemyre is referring to, the concerns is that it alters the solvency controls by asking that every SIG, no matter its size or the risk that it covers, be treated as if it were an entry-level SIG. And that's not really what that statute was intended to do. The statute specifically have different thresholds to address new entrants in comparison to SIGs that have been in business over 3 years. The concern is workers' comp claims are long-tailed and can run over 30 years. And we're a little concerned about just making that one change in that statute because these tails and the different sets of liabilities for those SIGs who've been in business longer are different. But I would say in response to trying to help out the smaller SIGs, each SIG actually has the opportunity under Section 6 of that very same statutory section to work with the division to alter the solvency protections and the solvency tools based on the individual size and the individual risks that SIG covers. So the second request, I don't know if you want me to address that too on the second request that they made, but I'll put it forward real quick, is that it asks us to amend or alter the requirement for SIGs to perform an annual audit of their members' risks. And this information is used to determine the amount of the member rates and assessments to the SIGs themselves. And information from this audit is used to calculate the rates and assessments based on the actual underlying rate factors. So if you're a smaller SIG, it's less work and it's more confined anyway. I mean, that actually goes by the size of the SIG. But without this audit, there's a potential of under or overpricing the risk pool. And underpricing causes insolvency, and overpricing may cause the small employers to actually pay more than is necessary for the risk pools. So those are the two reasons why we don't feel comfortable with this particular amendment, but we do feel that we are committed, just as a division, to working with each of the SIGs individually to really look at their solvency tools and their solvency protections, because as as Senator Settlemyre points out, they're not all the same size. One size shouldn't fit all, but the changes that are being requested in the SIG statutes right now wouldn't be helpful for making those distinctions. So I stand for any questions.
I appreciate that, and thank you for allowing me to ask that question, Madam Chair. In that respect, though, I think the number 2 amendment is very minimal, but it does a lot of great things for these self-insured groups. Continuing to do audits all the time can be rather costly and problematic. I mean, if there was proof that these previous audits that they've done, has there been any proof of any of the previous audits showing that there were problems in the past that needed to be corrected? I guess that's the question I have in front of me, because right now I'm very remiss to support this bill without at least entertaining the concept of amendment number 2. I guess that's a question to the division. Is there been proof in the audits of huge wide-scale problems that it is necessary to do these on a routine basis when needed?
So thank you, Senator Settlemyre. This is Barbara Richardson for the record. The actual issue with these audits has to do with determining pricing and based on the standard classifications. And based on our understanding from the industry themselves, they have not been using the standard industrial classification codes. So I would suggest that right away, since that's what they're based on, that there's a problem lying underneath the any kind of information that's come out. And as you probably know from other statutes and statutory requests that we've made, we, as a division, we try to be as efficient and try to be as accommodating to any kind of market and business that we oversee, because we don't want people to keep on providing us data or duplicative data or data that's not necessary to help them actually service their members and take care of the market themselves. And in this case, that given that they haven't been using the proper underlying tools, our fear was that taking it away right now is probably not appropriate.
Thank you for that. I understand the issues and concerns you've raised. I'm just not necessarily getting that type of feedback from different individuals. I don't know. Like I said, I'm very remiss to support this without the Second Amendment. Thank you. Thank you, Chair.
Thank you. Additional questions from committee members?
Chair Spearman, Senator Lang.
Yes.
This is Senator Lang. So I too have the same concerns that Senator Settlemyre brought up, and I'll just ditto his comments and just say that I'm going to have trouble supporting the bill unless we accept the amendment number 2.
Senator Pickard?
Thank you, Madam Chair. Since it looks like a vote might hinge on our positions, I share the same concerns and can't support the bill without that amendment. So thought I should probably weigh in and let you know that.
Thank you. Additional questions?
Madam Chair.
Senator Hardy?
Thank you, Madam Chair. If you're ready to allow a motion to accept amendment, what we call number 2, into the bill, I think that would probably be appropriate. And I was
almost ready, but I have some questions, so I was almost ready. Can I ask my questions? Commissioner Richardson, so I just need to understand. So I think the opposition to Amendment 2 stems from the way the bill is currently written without the amendment is, I heard you say you want to make sure that the pricing is right. Is that correct?
For the record, this is Barbara Richardson. That's correct.
Okay, say more about that. What does that mean for, as a consumer, what does that mean?
So for the record, this is Barbara Richardson. So basically, the prices and rates that the members actually calculate is based on what is known as their underlying risk. And since we're talking workers' comp, you have to think long tail. You have to think the fact that Nevada has the ability to open up workers' comp claims after the fact. They have a lifetime ability to reopen. So you have to make sure that you're understanding the actual underlying risks that are a part of the actual pool of members that are in these small businesses. For example, you don't want to charge a taxi cab driver the same as you would charge an office worker. You don't want to charge a construction worker the same as you would charge an accountant. It just so happens there's different risks involved in their work, and these annual audits are supposed to make sure that the pool of members and the employers haven't changed enough. For example, with COVID, there could have been a large swing in the type of actual work that was involved, and that would affect how much the risk was going to be calculated, and then it would affect how much the member had to pay into the SIG itself for the assessment and the rates. So the concern that we have is that if you don't have these audits, then there's potentially just a steady increase as you go along, and there's no review of the actual members' risks or if the risk pool changes. So that, again, it goes back to the underpricing or overpricing. It really goes back to the members themselves. And if there's not enough money being paid into this risk pool, there's an insolvency. And that really concerns us, because I think we mentioned at the first hearing, if you don't calculate these with good faith and based on underlying data and good data, then your insolvency as a SIG will cause all the other SIGs to go down because they have to take up and pay for in any insolvency. So we're really trying to figure out a way to work with each one of these groups separately, but we need to make sure that they're actually pricing their member pool correctly. And right now, based on what we've found, they're not. So that does cause us a lot of angst. And I do, like I said, I do understand requiring it every year, but I would say that removing the may or shall to may wouldn't change the fact that we still need them to do this to start the move in the right direction. It appears to me that if we let them out from underneath this requirement, we're never going to be able to get them back on track and provide them the information and the training that they need to understand these classification rates.
So, Commissioner, will you say what you just said? Explain it to me like you're talking to a kindergarten class. I want to understand who's the person that is paying the rate. You mentioned taxi cab driver versus office worker. If someone has a business and the workers' comp includes office workers, walk me through a scenario where that would be different if the office worker had a claim or the taxi cab driver had a claim. I'm trying to understand the similarities or the difference in really plain terms. And then after that, I'd like for our legal counsel to weigh in, and I see Senator Pickett's hand. But Commissioner Richardson first, then Mr. Keene next.
Certainly. So this is Barbara Richardson for the record. Basically, so say one of the members has only taxi cab drivers. So taxi cab drivers have certain risks for being on the road often. If their injury happens, it's more likely as a workers' comp claim to be much harsher, unfortunately, and it costs more because it might last for a longer period of time. Office workers tend not to have those same type of risks. Their chance of having a workers' comp claim is just much lower. So you want to make sure that if you have a pool of taxi cab drivers plus a pool of office workers, that you're not charging the office worker team, or you're not charging the member the office worker rate for taxi cab, because then you won't have enough money to pay the taxi cab claims themselves. And again, it goes the other way around. You want to make sure that if you have a lot of office workers and some taxi cab drivers, you want to make sure that the office workers are being charged that lower rate because their risk is going to be much lower and their claims amounts are going to be much lower. So in this case, it helps the actual members to not have to, again, overpay or underpay what they're actually the risk they're trying to cover.
So just as an example, because I'm trying to get this too, okay? Um, so if I am a company and I have office workers and the business next door is taxi cab drivers. If taxi cab drivers, if the person who owns that business is being charged, let's say $400 per employee, because they're taxi cab drivers, that same $400 could apply to me, even though what my employees do is different. Is that what you're after with this bill? I need to understand it, okay?
No, so this is Barbara Richardson for the record. That's exactly what we're after. We're trying to make sure that the SIGs themselves look at their underlying members' actual risk threshold, and that's all based on who are the members and what actual work they're doing for that particular year. And if you don't perform, if the SIGs don't perform these audits, then the members and based on the data, because there's lots of information about, why a taxi cab driver might be charged more and, what the risk is. But so if they don't actually price on this, then there's already an underlying harm to the SIG members themselves, again, who may be overpaying or underpaying. And in the long run, that hurts them. And I think that's one of our big concerns with this particular audit section. We really need to make sure that that's happening appropriately.
You mentioned something that sounds like you're saying SIGs, that's SIG or CIG.
I'm sorry. I apologize. It's Barbara Richardson for the record. Self-insured groups. We call them SIGs.
Yeah, okay. We have a lot of acronyms too in the military. People who are not, they like, huh? So if I'm understanding you correctly, and I guess this would go to, I want to understand Senator Settlemeyer's question too. If you're a small insurer, and you're being charged the same rate that someone with a higher probability of accident, then it's not in your interest, excuse me, not to have the audit, or is it in your interest to have the audit? One person should be paying $150 per employee, another person pays $400 employee, but I think what I hear you saying is that you don't know the difference unless you do the audit.
This is Barbara Richardson for the record. That's correct, because as everybody knows here in Nevada, we have changing populations, we have changing businesses, and a lot of the companies have who work in this arena. They actually have new people and people retiring all the time, moving in and out. So you want to make sure those rates are accurate. You don't, again, because you don't want to overcharge anybody, and you certainly don't want somebody who should be paying $150 for a risk paying $400.
And I think this will be my last question, and I'd like for Mr. King to weigh in. And and excuse my pedestrian mindset. I just really need to know and understand, so I know what I am or am not voting for. So the person who should be only paying $150 per employee, the SIG, the SIG who should be only paying $150 per employee, without the audit might be paying $400 per employee, which means that SIG would be overpaying per employee by $300.
So this is Barbara Richardson for the record. It's actually the member paying into the SIG. So it's one of the member companies. So it's even the smaller employer group who potentially might be paying more than is necessary.
Okay, all right. Mr. King, can you weigh in, please? And then Senator Pickett, I see your hand.
Thank you, Chair Spearman. For the record, Will King, Committee Counsel. Just in case that this bill is amended, I want to make sure that we're all speaking on the same amendment and that we all understand what it does, because a number of amendments have been floated in the last couple days. So the amendment I believe we're all talking about, identified as Amendment 2, is the one submitted by the Nevada self-insured groups and proposes amendments to NRS 616B.353 and NRS 616B.410. And starting with the first of those sections, there's no amendments to Section 1, which is the section which requires self-insured groups to enter into binding obligations to each other to provide excess insurance, to provide to collect annual assessments, and to have a deposit of a bond or a security in lieu of bond. And then subsection 2, which is where the First Amendment occurs, subsection 2A would say, and these are additional requirements in addition to the subsection 1 requirements. Subsection 2A would change the operation of that paragraph so that instead of, well, let me say it this way. Currently, the law says that at the time of initial qualification and until the association has operated successfully as a qualified association of self-insured employers for 3 years, then the conditions happen. The changes are changing until to as long as, and then eliminating the words for 3 years. And as I'm looking at that, I'm not sure what the difference is between until and as long as, and then I'm not sure once we delete the for 3 years, exactly how that clause would operate. It almost seems to me as I read it, that what that clause would mean is that those requirements in 2A would operate in perpetuity as long as the SIG existed. That's almost what it seems to me, but I'm curious as to whether the commissioner agrees with me or whether Mr. Wadhams, if he's there, agrees with that interpretation. And I'm asking this as a drafter. I'm not sure what to draft if I'm not sure what it means.
Commissioner?
So this is Barbara Richardson for the record, and Mr. Keene, you're accurate. It would make all of the SIGs act as if they were under the 3-year business thresholds. So there'd be no difference between a brand new entrant and one who'd been around for 20 years.
Perfect, thank you. And then the next change is in paragraph 2B, and 2B is the provision that provides what happens after 3 years of successful operation. And then they were changing the words as determined to if permitted by the commissioner. And in that case, I'm not sure what the distinction is there. It seems very similar, and I'm always cautious about making wording changes that don't seem to actually make any substantive difference, because the courts generally would interpret a change as having some significance. What would you think the significance of that change is? In both cases, it seems to me it's the commissioner exercising judgment as to whether that clause applied.
So this is Barbara Richardson for the record, and Mr. Keene, we agree with that. We did not see the difference.
Thank you very much, Commissioner. And for the record, Will Keene, Committee Counsel. And then that's the last change to that section. The changes to the following section were, and that is 616B.410. And those changes are a little more clear to me as to what they would be doing. It's about the audits, and as the law stands now, it would be the commissioner shall cause to be conducted at least annually an audit. And the language would be changed to commissioner may cause to be conducted whenever deemed necessary an audit. And as I would read that, it's changing it from a requirement that at least annually there is an audit to the commissioner has the option to audit whenever deemed necessary. I'm not sure whether you see any significance in the deemed necessary portion or whether you would read that as meaning you could continue to audit frequently, multiple times a year, or whether you would have to, whether you felt you would have to engage in a process to determine if it was necessary and therefore might not be able to audit as often as you wished.
This is Barbara Richardson for the record, and Mr. Keene, we agree with that as well, that interpretation. And I think that's what my concern is that we were potentially asking for a change in the statute that we would not encourage or try to move forward because of the situation where the SIGs are in right now. That might be different in the next legislative session after we've worked for them, but currently it would continue, the audits would continue. We would deem them to be required.
I see, and for the record, Will Keene, Committee Counsel. So with these changes, would you see this as something that you would proceed with multiple audits a year, or at least one audit a year, but however, then a SIG could challenge your determination that it was necessary, and therefore start a process where there had to be a determination as to whether your determination was correct, therefore putting off the audits. Is that one of the purposes of this language?
So this is Barbara Richards for the record. I'm not sure what the purpose of the amendment is, since we don't actually agree with it and we're concerned about it. So I'm probably not the one to be asking or answering that question. But I would say that unless there was something significantly wrong, which we don't interpret running into, we wouldn't, as a division, do more than an annual audit as it stands. So, but I believe that the person who proposed the amendment might be able to give you a better answer on what their intention was.
Madam Chair?
Thank you.
Yeah, just a minute, let's see, Mr. King, were you getting ready to ask?
Thank you, Chair. I just want one last clarification. So Commissioner, that language, the whenever deemed necessary, do you see that as being something that you can decide on your own if necessary, or would that necessarily be a process that a SIG could challenge your determination and therefore put off the audit for the length of time of their challenge of your determination and the determination I'm talking about is your determination under the language as revised, your determination that an audit should be conducted. So if every year you made a determination an audit should be conducted, every year they could challenge your determination that an audit should be conducted.
So this is Barbara Richardson for the record. Our statutes in general allow those kind of challenges. So I would assume that a challenge would be applicable. A challenge is, it just delays the process and takes us further down the road without necessarily fixing anything. But we believe that the industry always has the right to challenge anything that might be a may.
And thank you. And Sheriff, if I could just ask one more question for the record, Will Keene. So as the language stands now, without the amendment, you would be auditing the SIGs at least annually, and there would not be an opportunity for the SIGs to challenge your right to audit them.
So this is Barbara Richardson for the record. I'm Mr. Keenan, I'm not quite sure I would interpret it that way. And I apologize if that is the way you'd like us to interpret, I can certainly understand that. But again, I go back to anytime that insurance company, a SIG, I mean, anybody we regulate, I'll just say it that way. If they feel aggrieved by any decision of the division, they always have a right to challenge or ask for a discussion or ask for a hearing. It would change whether or not we, put a process in place, but I don't think it changes the rights of the actual aggrieved or potentially aggrieved party.
Thank you, and thank you so much, Chair Spearman, for allowing me to ask those questions.
Thank you, and I know that Mr. Wadhams is on the phone. I had said, Senator Pickard, if your question deviates from the discussion that we're having right now, will you allow Mr. Wadhams to come in first, or if it's
absolutely, Madam Chair. If you want to ask him the question first, I think I'm asking on the same line, and it might add some clarity to the discussion.
Mr. Wadhams?
Madam Chair, this is Cesar Melgarejo. BPS, can we get Mr. James Wadhams on the phone? He is registered online with the last three numbers of 020.
Yes, 1 second, Chair. Please stand by. Hi, this is Broadcast. I'm so sorry. Can you repeat the last three numbers, please?
It's 020.
Yes, Chair. Please stand by. I will call for that number. Chair, you are now
Hello?
connected.
Madam Chair?
Yes, sir, we can hear
Hello?
you.
Oh, fine. Thank you, Madam Chair. This is Jim Wadhams, W-A-D-H-A-M-S. I apologize for not being in the committee room. I'm directly across the street and passed the test for the day, but I could not get permission to get in the building. But I'm available for questions if I can answer anything that's being asked.
And I think the questions probably center around, number one, the purpose for the amendment. What would be the substantive changes, if I understand our LCB council? What are the substantive changes that without that amendment wouldn't carry the same thought?
Excellent. Thank you, Madam Chair. Again, this is Jim Wadhams. Let me try to address them briefly because the amendments are very brief. And I first want to express my appreciation to Commissioner Richardson and her staff who spent actually more than a few hours talking about this and the purpose of it. The first section we've asked to be amended is in 616B353, and it relates back to an issue that came up just recently. These SIGs, as the committee members may have already heard, have been in existence for 25 to 30 years in some cases, and have operated under, in that particular section, the qualification of having a tangible net worth of $2.5 million in the aggregate. These SIGs have operated under that for, again, up to about 25 years and pay their claims. The modification was to clarify an interpretation that has been presented to the SIGs that they can only qualify if they have enough money in the bank, that is an asset test, for 3 years. After that, they have to pass subsection B, which is a cash flow test. And I think there's a letter in your committee packet from an independent accountant that reflects the history of that. So I'm not going to go into the detail, but it doesn't change the basic financial requirement. It just gives the opportunity for these SIGs who have successfully existed on the asset test to continue to be under the asset test, as opposed to being forced into the cash flow test and fail to qualify because of their activity level may be low. They could be builders and they weren't building early into COVID. They could be cab companies and the transportation was slowing down. Doesn't mean they don't have the assets to pay the claims. It just means that their revenues were not the same. And the interpretation was issued last fall that there is no choice. After 3 years, you have to meet the revenue test. And so that change was designed to address that simple problem. And I'll answer questions, but let me then move to the second amendment, which is also very simple. And it's a simple change from the may to from a shall to a may. And the problem here for the committee is under the current statutes, the SIGs are audited by outside auditors for their financial statements, which are submitted under 616B 404. The commissioner has power to examine and audit these SIGs anytime the division deems it appropriate under 616B 395. And so the amendment we're asking for is in 616B 410 is to change this from a mandatory annual audit as an additional one to a discretionary one that the commissioner still has the power to do anytime she feels like it's necessary. That language is almost identical to what exists in section 395. And the reason we've asked for this is because if literally interpreted, we could have to undergo the cost of creating an audited financial statement an annual audit by the commissioner, and in the same year, potentially a full examination by the commissioner. That would be three expenses essentially covering the same information. And frankly, from an economic standpoint, that doesn't make sense. She has the power under 395 to examine anytime to protect the solvency. And the final comment, the definition of solvency is provided in the statutes, and that's the ability to pay the claims. So we are not asking for these to take away the commissioner's power. She will have the power to examine any time that she feels uneasy about the solvency. But we do need to make sure that these companies don't lose their certificate to stay in business simply because their cash flows are low, even though their assets are adequate. They can pay their bills out of their assets. The cash flows are not pertinent. To force the change, which is why we're making that First Amendment, could potentially put them out of business. In the discussions with the commissioner, she's indicated it's time to revise the statutes and the regs. That's not appropriate this session, this late, but this gives some breathing room for these companies to stay in business. Doesn't prevent them from being audited, from being examined, but it just eliminates the potential that they would lose their license while they're still healthy. Thank you.
Okay, what I'm going to do now, I just got word that we have one of the presenters, Assemblyman Orlichter, has to be in another meeting at 9. So what I want to do is I want to push the pause button on this, and we'll come back to it. While we're taking a pause from the work session, Commissioner Richardson, I'd like for you, in light of what Mr. Wadhams has said, I'd like for you to present a response just as soon as we come back. Is that okay?
Yes, ma'am. For the record, this is Barbara Kitson.
Yeah. Otherwise, I'm leaning more towards let's try to figure out how this is going to work for yes, the small businesses, but also how is it going to make sure that those who are new entrants aren't picking up the tab for those who have been in for a long time. And that just may be, as I said before, my pedestrian understanding of it, but I want to be sure I know what I'm voting on, okay? So we're going to take a pause on the work session for this, and if Assemblyman Orlichter, if he is ready, we will move to, I think it's 4:37. And for those of you who are listening, we've got this time next week will be the last day that bills have to pass out of committee or die. So there are a number of things that happen, not according to schedule, but we try to do that so that we make sure that we hear and process all bills, as many bills as we can, with the fairness that is due to the to not just the drafters, but also to the person who's bringing the bill. So with that, let's open up the hearing on Assembly Bill 437.
Madam Chair, it's Assembly Bill 442.
442. Okay, I'm sorry. I was trying to get back to my notes. Don't tell anybody. Okay. Assembly Bill 442.
Thank you, Chair Spearman and members of the committee for allowing me to present now. I am David Orentlicker, representing Assembly District 20, and I'm here today to present Assembly Bill 442, which revises continuing education requirements for healthcare providers who are authorized to prescribe controlled substances. These providers will have to complete training to better identify patients who have or are at risk for developing substance use disorders. And while it's a new requirement, it doesn't add to their total number of credits they have to earn. The credits they have to earn for this particular training fits within their total credits that they now have to satisfy. The bill is sponsored by the Interim Legislative Committee on Healthcare, and while I was not a member of the committee, its chair, Assemblywoman Leslie Cohen, invited me to carry the bill through session. I am pleased to present it before you today. At this point, I would like to turn over my time to Dr. Andrea Peterson from the College of Pharmacy at Roseman University of Health Sciences to provide additional background on the bill and discuss the goals and the purposes and so on. So thank you.
Thank you, and thank you, Chair Spearman and members of the committee. For the record, my name is Andrea Peterson, and I am a clinical pharmacist. There we go. For the record, my name is Andrea Peterson, and I am a clinical pharmacist for Dignity Health St. Rose Dominican Hospital and co-founder of the Empowered program. Empowered stands for Empowering Mothers for Positive Outcomes with Education, Recovery, and Early Development. This program originated in 2017 after we discovered an increased number of infants suffering from neonatal absence syndrome, also known as withdrawal, and a need for improved care coordination for pregnant women experiencing substance use disorder within our community. We support these women by aligning them with services throughout their pregnancy and continue to support them and their infant for 1 year postpartum. It has truly been a privilege to see the extraordinary strength of these women as they change the trajectory of their lives for their child. In November of 2019, we had the opportunity to present Empowered to the Interim Health Committee, and were originally going to seek funding to continue this work, and then the pandemic hit. We understood the financial impact this would have on the state and instead came up with a no-cost policy option that has the potential to impact many, not just pregnant women. This policy option revolves around continuing education credits for SBIRT, which stands for Screening, Brief Intervention, and Referral to Treatment, and was adopted by the Interim Health Committee. Many thanks to the members of that committee and Dr. Stephanie Woodard from DHHS for their help in drafting this legislation. As I mentioned, SBIRT stands for Screening, Brief Intervention, and Referral to Treatment. It is an evidence-based approach that can be rapidly performed in a number of settings to identify patients with substance use disorder or patients who are at risk for substance use disorder, and is a Medicaid reimbursable service. It has been found that utilization of this method by healthcare professionals can aid them in identifying and successfully assisting individuals not actively seeking an intervention or treatment for their problem, and will set both providers and patients up for success in addressing the opioid epidemic in our state. This practice is recommended by all major societies, SAMHSA, which is the Substance Abuse and Mental Health Services Administration, and the United States Preventative Services Task Force as a best practice and as a standard of care. AB 442 will require that providers who can prescribe controlled substances complete a 2-hour training on SBIRT once, and will qualify for existing continuing education requirements related to substance use and other addictive disorders and the prescribing of opioids set forth in AB 474. Those who are newly licensed in the state of Nevada would have to complete the SBIRT training within the first 2 years of their licensing, and those who are already licensed in Nevada would need to complete the training prior to January 1st, 2024. Thank you very much, and both Dr. Stephanie Woodard and I are available for questions.
Thank you. Dr. Assemblyman Orlicker, is that the end of your presentation?
Yes, thank you, Chair.
Okay, thank you. Committee members, questions?
Madam Chair.
Yes, please.
We already have some requirements for pain management and addiction in the NRS. Do we, I mean, this obviously overlaps if the physician, for instance, gets the 2 hours of SBIRT training, does this not also count for the addiction and pain management requirements?
David Orrin, Liquor Assembly District 20 for the record. I believe so, but Dr. Peterson or Dr. Woodard can confirm that.
So Stephanie Woodard for the record, just to confirm, the intent of the legislation is not to add an additional 2 hours of continuing education credits to the existing 2 hours required through Assembly Bill 474 from the 2017 legislative session, but to be able to allow the SBIRT trainings to actually take the place of those 2 required hours.
So this would take the place of and not add to, correct?
Stephanie Woodard for the record, correct.
Thank you.
Madam Chair, I had a
Additional
question.
questions? Yes, Vice Chair.
So on section 8, sub 2, I had a question around the not using the continuing education for the screening. I didn't understand that particular provision, and were they able to do that before? Because this is a person already has an existing license. So why are we putting this may not use continuing education, the screening for brief intervention or referral for treatment approach?
David Orient-Licker, Assembly District 20 for the record. Dr. Woodard, do you have a, I'll have to take a look at this provision specifically. But
Sure. Stephanie Woodard for the record. So my understanding in reviewing this section is that they wanted to make clear in statute, and Dr. Peterson, please correct me if I'm wrong, that these hours would not be used towards ethics hours. And they wanted to make sure that that was specifically called out. But Dr. Peterson, please jump in if you have something else to add.
Andrea Peterson for the record, I believe that she's correct.
Okay, so just a quick follow-up, so after you get the license, you have your continuing education, but typically continuing education is used for any additional training. And so you want them, I'm still not understanding why you don't want them to do it. Why you don't want them to use continuing education as some of their hours towards this, because isn't that the point? After you get the license to continue classes to shore up certain areas?
So this is Stephanie Woodard for the record. Yes, we absolutely want these to count for continuing education credits, but each board has authority to determine how many continuing education credits are required during specific licensure periods. And during the process of delineating the kinds of continuing education credits that a licensee is required to have, there is typically a subset of those requirements that determine how many hours of ethics training a provider may be required to have, as well as particular other specific types of continuing education hours. So my understanding is this section of the bill is to specifically say that these continuing education credits should count, but they should not be counted as ethics hours, as guidance to occupational licensing boards as to how to classify these hours.
And Madam Chair, final question. So what continuing education hours will fit the ethics component? And did these fit the ethics component before this bill?
For the record, Andrea Peterson. So this education requirement will fulfill substance use and other addictive disorders and the prescribing of opioids set forth in AB 474.
Okay. Thank you for that.
Madam Chair.
Any questions? Yes, Is that Senator Settlemyer?
Thank you, Madam Chair. I think mine might just be a technical correction. If you look at the digest on line 3, it says opticians. Yet if you look further on lines 13 and 24, it says optometrist. I assume that's a mistake, or are you trying to get all of them? Just trying to figure that out.
David Orient-Licker, Assembly District 20 for the record. We'll check to make sure. Our goal is to get all people who are authorized to dispense prescribed controlled substances, so we'll confirm, and Dr. Woodard may know for sure on that, or Dr. Roseman.
or potentially even our council to figure out if that was, maybe I'm incorrect, or is that just a drafting error?
Madam Chair, if I may weigh in. There
Yes,
is,
please. That's
there,
Senator Harvey.
there is a difference between an optician and an optometrist, and the optometrist should have the ability to use the controlled substance and not the optician. I think Senator Sendelmeyer has scored another point.
Thank you. We'll fix that for the work session.
Additional questions? Committee? Seeing none, is there anyone in the room who is here in support? And we'll go 15 minutes per segment, 15 minutes support, 15 opposition, and 15 neutral, 2 minutes per individual. No one in the room?
Madam Chair, there's nobody else in the room.
Okay, broadcast, let's go to the phones.
Thank you, Chair. Good morning. If you would like to testify in support of AB 442, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of AB 442, please press star 9 now. Chair, you have no callers in support at this time.
Okay. Let's go to opposition.
If you would like to testify in opposition of AB 442, please press star 9 now to take your place in the queue. Chair, you have no callers in opposition at this time.
Those in neutral.
If you would like to testify neutral on AB 442, please press star 9 now to take your place in the queue. Chair, you have no callers neutral at this time.
Thank you. Assemblyman, do you have any closing comments?
Thank you, Chair David Orient Liquor, Assembly District 20 for the record. Thank you for your consideration. Thank you to the interim committee, to Drs. Peterson and Woodard for their help with this, and we will fix the problem that Senator Sedelmeyer pointed out, and if there are any other concerns you have, please let me know.
Okay, and with that, we will close the hearing on Assembly Bill 442, and we will go back to our work session. And I believe we were with Commissioner Richardson was going to respond to Mr. Wadhams.
Thank you. For the record, this is Barbara Richardson, the Insurance Commissioner for the state. And the first thing I wanted to address is we did speak with Mr. Wadhams for quite a few hours, and I think both sides learned a lot. But I think one of the things that is still sort of pending in everyone's head is that that Mr. Wadhams keeps on claiming that there's some type of crisis or some type of concern all of a sudden with statutes that have been in place since 1993. And it seems to me that if you read the entire statute, some of the crises that are, well, we're focusing on two, are just, they're not, they don't play out. So for example, in the first one, the whole issue about having a change for the underlying amount that a 3-year-old SIG has to hold versus anything over 3 years. We keep on sort of talking to him, and I think I presented here, but I may not have been clear enough, that under that very same statute, under Section 6, it allows the opportunity for the SIG themselves to work with the division to alter the solvency protection amounts and solvency tools based on the individual risks that the SIG covers. So these smaller SIGs don't have to fall under the 7.5 million threshold if there's alternatives that work for them. As of this time, we haven't had all of the open discussions that are necessary to determine what that might be, but we have started discussions, and we also allowed them to be out of compliance for this calendar year in order to give everybody a year to right set, because it was our understanding that the SIGs did not understand that this statutory section would allow them to actually make changes, which is why it appears they're thinking that something's wrong when in fact there's not. And then on the second amendment question or specific topic, Mr. Autumns is conflating three different oversight requirements and attempting to claim that there's again, a crisis situation where there's not. So the requirement to provide financial statements is a general requirement for any ongoing concern. So there's not usually a cost other than to email to us for that going concern to provide financial statements to the division. We get them from all of our business entities. And then the examination statute he points to is focused on financial statements. So basically these examinations are done every 3 years, and they're actually based on the financials that have been supplied. And what the concern is Mr. Wadhams is confusing the audit with these other financial reviews. This audit that we're talking about is not a financial review at all. This audit is to properly classify employees for members to determine the rates to pay to protect these employee members. So trying to claim that all three of these things will cause a cost crisis of any sort is misleading at best.
Okay, I understand Mr. Wadhams is in the room. Can you respond, please? And every round, you know, Jacob's ladder goes higher and higher, but every round I get more confused and confuser. I don't know if that's a word, but I'm not comfortable that I understand exactly what I'm being asked to vote on. So, Mr. Wadhams, can you respond, please?
Thank you, Madam Chair. I am in the room and I appreciate the opportunity. And let me just state again, Commissioner has been very forthcoming in discussing this issue. We had thorough, robust discussions. And so I hope the committee understands that this is not intended to be an argument with the Commissioner herself. We are talking about some policy questions that I think that they seem bigger because they're so subtle. And let me start again by observing that we have two goals. One, to make sure that those SIGs that are healthy can survive until they are found not to be healthy. And the crisis isn't immediate, but has been imposed because of letters that each of the SIGs received that they will no longer qualify for a certificate if they don't post a bond. And the problem that they have found is that these bonds are not available in the marketplace, which means they would have to go to court or go to a hearing first to defend their solvency and put financial records out, and then probably have to take that to the district court. The issue comes back to the basic solvency question, and I respect that the Commissioner raised that because SIGs are grouped together, and if one member becomes insolvent, then the other ones have to pick up the difference. So the SIGs do not support any risk and support good, adequate regulation. The problem has been that they have been told that they will lose their certificates if they don't meet the second test as opposed to the first. Now, in discussions we've had, the Commissioner and I have looked at that Section 6, and I think, as an attorney, it may give that kind of discretion, but the uncertainty of that could be clarified if we make the alternative between Test A and Test B clearly as an alternative. That doesn't preclude the Commissioner from some other finding but at least in terms of maintaining the basic certificate of authority to continue in business, it shouldn't be interrupted if they're managing to pay their claims. So the amendment's subtle, but it's designed to just overcome an interpretation that first appeared just a few months ago. The second piece, and I apologize that this is complicated, but over the course of time, the legislature has given plenty of power to the commissioner, and rightly so. We think the examination power under Section 395 is comprehensive and allows that examination to occur anytime there is a concern. The audited financials are common throughout the industry, but they also address the same issues we're talking about the adequacy of capital, the adequacy of reserves to pay the claims, and then the third, where we're asking for the amendment not to eliminate the authority for an additional specific audit, just to make it discretionary rather than mandatory. It is possible that a small SIG could face 3 audits in 1 year, and we wouldn't think that that would be necessary. If their solvency isn't an issue, the commissioner could launch the full examination, and if they're insolvent, hopefully they would be taken out of the market quickly. We would all support that. So that also is a very subtle change, to take it from a shall to a may. And one of the reasons in our discussions that I raised that is that annual audit under Section 410 has not been done. And it hasn't been done because it hasn't been necessary, or at least appears not to have been necessary. And the risk that it suddenly could become mandatory or be interpreted as mandatory, we wanted to make the practice consistent with the way it's been. So, final comment, and I appreciate the opportunity to be in the room. We're not trying to take away any power of the commissioner. Regulation in this area is very important. We want to make sure that these SIGs don't have to fight for their life if they are otherwise solvent and paying claims. Thank you.
Thank you, Madam Chair. This last discussion raised a preliminary question before I get to the one I had, and that's who does the audit currently? Does the division do the audit, or does the SIG provide audited records to the division?
So I assume that's to me. So this is Barbara Richardson for the record. Thank you, Senator Pickard. We actually discovered in 2020 that quite a few statutes were not being followed, and this happens to be one of them for years. Turns out it was based on a misunderstanding. And it took a long time for the industry and the division to figure this out, is a misunderstanding of the phrase standard industrial classification code. And which is, this is probably more technical than we want to talk about, but they were they were interpreting that particular set of words to mean something, or a particular classification code that had been around in the early 1990s, rather than actually looking at the words that actually just means pick a standard industrial classification code. There are ones available. And so there was a whole series of things that the SIGs were not doing because they had interpreted that phrase that way. And this particular audit has that phrase in it. So we discovered, as I said, I'm embarrassed to say this, but honestly, on the record, they have not been following the statutes for a long time, which is why we start talking to them.
But my question was, who is responsible to do the audits?
Under the statutes, this is Barbara Richardson for the record, the audits themselves are the SIGs for the members. Yes.
All right, that's an important distinction for me, because the way I'm looking at the proposed amendment, and I guess I was looking at the amendment, kind of reading it backwards, and maybe this is for Mr. Wadhams, since he's the one who drafted this. as I read the revision to 616B 410, changing it from mandatory to permissive whenever deemed necessary, it seems to me then the prior two amendments are really to conform the rest of the statute to this change. Is that an accurate reading?
For the
Mr.
record,
Wadhams?
yeah, I'm sorry. For the record, this is Jim Wadhams, and let me try to answer that. It requires just a little bit more distance than to get directly to the answer. The amendment to 410, if we read the exact first line, it says the commissioner shall cause to be conducted at least annually, an audit of each association. That audit is one conducted by the commissioner or by somebody that she contracts with to come in and do it. So it is a state-ordered audit. The audit that is currently required to be developed and hired out by the SIG itself is actually in 616B 4, hang on one second, 404. So when they submit
404, right, I see that.
404. So the SIG is required to produce an audited financial statement. The section 410 mandates that the commissioner have an additional outside audit. And then if we can look quickly at section 395, that is common throughout the insurance code. The commissioner, because solvency is an issue for all types of insurance operations, she has the unlimited, unfettered power to examine whenever and however she deems necessary. So 395 is the potential for yet a third audit. Now, one is mandatory. We have to have audited financial statements. We're simply trying to correlate between the state-generated examination under 395 and the annual mandated audit under 410 to leave the discretion to have it done whenever it's necessary, but not make it mandatory, because that just adds an additional expense, which we think is redundant and doesn't add to the information base. The commissioner has begun acquiring more information in a more sophisticated way. We have no problem with that either. That's why that element's not an amendment here. So we're trying to minimize the mandatory number of audits. That's what that section is for.
I understand the chairman wants to interject.
Thanks, Senator Pickard. Here's what I'm going to do. I did not realize that this work session would be this long. I did not know that there were still this many questions, but appreciate the opportunity to try to plow through it and figure out what's going on. What I'm going to do is, Ms. Margarejo, let's move on. We'll pause the work session for this Bill 45, and we will bring it back next week. I have asked Mr. Margarejo and Shelby Parks to work together to schedule a huddle later, so we can figure out we can find the answer to Marvin Gaye's question, what's going on. Okay, and thanks everybody for your understanding. As I said, these are times when we're trying to get through a lot of things, and I want to make sure that we're doing them judiciously and fairly. And I'm sure, like my other colleagues, you all understand we don't want to vote on anything that we don't understand. And so with that, we'll pause this work session for this. And I want to move to, I understand that Assemblywoman Torres is waiting, and she has a number of people who are probably waiting on the telephone in support. I was reminded last week that for some people, when they wait a long time on their cell phones, there is a charge. So I want to make sure that we're being fair to them as well. Assemblywoman, are you ready to present your bill? And do we have everyone in the room that you will need?
Yes, Chair, and I believe that Attorney James Kemp is on the Zoom. Is that correct? Yes, I do not see him.
Okay.
Okay, there he is.
Yes, so we will proceed. Now, I'll just explain to those of you who are new to this, to the legislative process in the last, under 30 days for the session to go forward. There are a number of things that we have to change at the last minute, so appreciate your understanding. When we make changes like this to accommodate people, understand that karma's watching, and one day it may be you, and karma will say back at you. So, Assemblywoman Torres, please proceed, por favor.
Thank you, Chair. Good morning. And thank you, Chair Spearman and members of the committee. I'm happy to be back in the Senate Commerce and Labor Committee to close out my week. I am Assemblywoman Selena Torres, proudly representing Assembly. I'm sorry?
The best committee in the Senate.
I won't fight you there. I am proudly representing Assembly District 3. Today, I am here to present AB 222, which revises provisions governing employment practices. Before I begin, I would like to provide a brief roadmap of today's presentation. So first, I will begin and provide the committee with some background information, talk about the problem that this bill aims to resolve, and then I will invite Attorney James Kemp to make additional remarks and complete a walkthrough of the bill. Throughout the COVID-19 pandemic, workers have reached out to express their concerns for safety. This concern has not been limited to the stories highlighted in the news and social media. Many hardworking Nevadans have reached out to express their fears of reaching out to their employer about safety concerns because they were scared of retaliation. COVID-19 has exacerbated this issue as essential workers continue to go to work during the height of the pandemic and in many instances felt unsafe and feared retaliation for speaking out. Nevada workers deserve to feel safe and should feel comfortable talking to their employers about unsafe conditions without fear of retaliation. Before I dive into the sections of legislation, I think it's important to understand how this policy expands employee protections. Currently, if an employee feels unsafe at work and reports to the external authority, like OSHA, a regulatory body, or the Labor Commission, they are guaranteed whistleblower protection, and that is only through case law. It is not codified in the statute. However, this protection is not guaranteed to employees who report this conduct to a supervisor or other appropriate authority within their corporation. Nevada must encourage employees that find their working conditions unsafe to report these conditions to their employers. This is beneficial to employees and employers. It encourages employees to talk to their employers about unsafe working conditions so that employers may quickly address the issue. This really empowers the employer to have conversations with their team about safety and deal with issues in-house. It prevents accidents since employees feel confident talking to employers about unsafe working environments. And when an employee knows that they can come to their employer about an issue, it creates a better working relationship, but for the employee and employer. Over the last few weeks, myself and NJA have worked diligently with stakeholders on an amendment to provide clarifying language. While the amendment is not ready today, I know that we are close to finding some type of agreement between ourselves and other key stakeholders, and I'm confident that we will be able to get many of our stakeholders to neutral with that language. So I really do want to, on the record, thank the stakeholders for continuing to collaborate with us and work with us so that we can have a greater conversation about how this issue impacts employees and how it impacts employers. At this time, I would like to introduce Attorney James Kemp, who will talk about what the bill does and kind of where we're going with some of our language in an amendment that'll be available before our work session.
Thank you. Good morning, Chair and committee members. I'm JP Kemp on behalf of the Nevada Justice Association. Here in support of AB 222, I want to thank Assemblywoman Torres for bringing forth one of the most important employee protection and workplace safety bills in this session. AB 222 will fill an important void that has been left in Nevada law for a number of years. When the Supreme Court of Nevada ruled on a case in 1989 called Wiltsey versus Baby Grand Corporation. In that, they held that there is whistleblower protection under Nevada common law, but it only extends to the point where an employee reports conduct about conduct in the workplace to a government agency that has regulatory oversight. An employee who merely does what's called internal whistleblowing, reporting it within the company, within the workplace to the employer, has absolutely no protection. So it forces an employee to, if they're going to have any protection at all, if they want to complain about illegal or unsafe things that are happening in the workplace, they literally have to call the police. They can't just go to their employer and expect to have any protection if the employer gets upset. You know, safety does often cost money, and employers get upset and they turn around and say, well, rather than fix the problem, I'll fire you, and that fixes my problem for me. This is a huge hole that was left when the Supreme Court said, no, we're only going to protect whistleblowers that actually go to the government. This is inconsistent with the majority of other states that are out there that do protect this internal whistleblowing and give protection to employees who do bring the information to the employer and then get retaliated against. I want to make sure we point out this bill is really aimed at bad actors. Good employers are not going to have a problem with this because they do the right thing. They fix things, they address the employees' concerns. This is really aimed at those bad actors out there who would put their employees' safety at risk by not only not listening to what the employees say, but not taking action to correct problems in the workplace. You know, Section 1 of the bill basically provides this this protection. It provides if an employee suffers an adverse employment action as a result of this internal whistleblowing or refusing to do something unsafe or illegal in the workplace, which is also arises out of the common law, but this would codify it, that they would have protections. They would be able to pursue the employer for remedies. When somebody gets fired under a situation like this, it has a great impact on the worker and their family. And this would provide remedies, including an order of reinstatement, lost wages and benefits of employment, and damages, compensatory damages for things like emotional distress and harm that's caused. And in an appropriate case, it does call for punitive damages. And this will create an incentive for employers to make sure they step up and do the right thing. And for those that don't, there will be consequences. And it's very important to workplace safety and employee protection in Nevada. There's another part of the bill that I just wanted to highlight real briefly, and that is it's a fix in the discrimination statutes. There's a question as to the time limits to bring a lawsuit for discrimination after the Equal Rights Commission or the federal EEOC finishes with its investigation, and they issue these notice of suit rights. The way that that NRS 613.430 was set up before, it only talked about a right to sue notice issued by Nevada Equal Rights Commission. This clarifies that you still have the 90 days after the US EEOC issues its notice of suit rights. So it basically harmonizes and keeps makes sure that you have enough time to bring the case under both statutes by saying you have 90 days from whichever one is later, because they aren't always issued at the same time. There's very often several weeks or even sometimes months time difference between when those are issued. But this will allow the cases to be brought together. So there's that aspect of it as well. And I would encourage the committee's support of AB 222. There is still some fine tuning that's being looked at among the stakeholders. We're continuing to work on it, but this is an important employee safety, employee rights and workplace safety statute that will fill an important void in Nevada law. Thank you.
Thank you, Chair Sullivan Torres. For the record, at this time, we're open for any questions from the committee.
Okay. Thank you. Committee members, any questions?
Yes, Madam Chair.
Let me go to Senator Settlemeyer and then Vice Chair, you're next.
Actually, it was Pickard, but Vice Chair can go first if she'd like.
Okay.
Thank
Vice
you.
Chair, Mr. Pickard, Vice Chair, and then Mr. Settlemeyer. Did I get that order right?
Okay. I just had a question
Okay.
on section 4. So, so you changed the timeline. Well, you tried to make them a little bit more congruent. But what if there's like a substantial review? So typically, like like NERC will kick it out, and then you want a substantial review to try to make sure that there was a proper procedure done at the NERC level, and then it'll go to the EEOC office. And so how will that timeline work in that scenario? And then there's another question, if you would, I'll just stick with that question.
Assemblywoman Torres, for the record, I'll answer part of it, and then I'll go ahead and defer to the attorney to kind of provide some additional remarks. But presently, we have a work share agreement that exists between NERC and the EEOC, and the present agreement allows for the filing of a charge of discrimination, harassment, or retaliation with one agency to simultaneously file with the other. So that agreement already exists, but it's not in statute. And so my understanding from the attorney that's present with us today, that this dual filing process has had some issues, and I did speak with the administrator for the NERC office regarding this issue as well. And so right now that exists with this work share agreement, but it's not in statute. So there's been some instances where the work share agreement has not been honored, and then they contact NERC, and then they have to go back and to fix it. And so I think that the attorney can kind of give some additional remarks on that.
Yes, that's correct. For the record, JP Kemp, Nevada Justice Association, the work sharing agreement does provide that when you file with one agency, you file with both of them. It's simultaneously filed with both. Whichever one you file with first is generally the one that does the investigation. To answer specifically Vice Chair's question, if it does go through the Nevada Equal Rights Commission and a decision comes out and a substantial weight review is requested, this would continue to toll the time limit to bring a lawsuit until the U.S. Equal Employment Opportunity Commission finished its review and issued its own right to sue notice. It's whichever one is later. So it does provide for the administrative agencies to do their job without running the clock out and forcing somebody to go file a lawsuit before the administrative agencies have finished. And so that's how that works. And I hope that answers the question.
It does. I'm just, I'm kind of glad you guys are getting into this section. I know Assemblywoman Torres' bill does some other things, but there's also an issue within the substantial review in terms of individuals who get their claim kicked out of NERC, and they don't really know how to do a substantial review. And sometimes that may or may not. Typically, they come in pro se. That's why they go to NERC in the first place. And so when it's kicked out for the substantial review, there is nothing that tells you how to freaking do a substantial review. And I think that since you're tampering with 613430, this might be an opportunity to at least say that you need to give like a simple skeleton letter of how to file a substantial review. And then if the complainant needs to talk to NERC, that they're actually allowed to talk to NERC without them triggering some kind of sanction against them. Because typically what I've seen is that it'll get kicked out of NERC, and then they'll send the letter saying, you can no longer contact this office ever again. And you're like, holy smokes, I don't know how to do what I'm doing, right? And then, you understand what I'm saying? Like that's the knit and grit that's happening in the space. And if we have a chance to like kind of spell out a little bit of that, saying like if a person contacts NERC after they get kicked out for one time for clarification, there should be no sanction to that complainant, although they're on another pathway to either get a lawyer and pursue in court or go get a substantial review. So
if I could address that, yeah, and I agree, it can be an issue. My experience is that mostly the Equal Rights Commission letters do mention that they can file a substantial weight review. There usually is some correspondence from the EEOC also, but it can be very confusing for the uninitiated, and there probably is room for improvement in that process. The Nevada Equal Rights Commission, with their letter, gives I think it's 15 days. It's a strict limit, though. They say it's a strict limit. I think it's 15 days to file a request for reconsideration with them, and then they have the opportunity after that to seek substantial weight review. And I think their letters do say that, but again, there could always be greater clarity, and perhaps they should have better instructions on their website or something like that. I agree, it's a room for improvement.
Madam Chair.
Okay. So I think we have Senator Pickard and then Senator Sotomayor. Hope we got through
Thank
order.
you, Madam Chair. And I'm glad Senator Neal went first, because she went a lot deeper into Section 4 than I would have, and she resolved my question there. So my other question has to do with Section 1, particularly Sub 2, B, D, and E. But backing up first in Sub 1, we talk about denying employment or promotion. And since this is going to apply to non-union, non-CBA type employment as well, I'm a little concerned about its intrusion into our right to work state. Now, I will say at the outset, I'm a member of NJA. I certainly believe in people's Seventh Amendment right to pursue redress, and certainly the ability to uphold their common law rights for protecting whistleblowers, and I agree with that. But this seems to go much beyond that. Mr. Kemp, isn't it true that punitive damages, currently I'm looking at Sub E right now, are not allowed in these types of cases? This would be a substantial exposure to employers for punitive damages.
So Senator Pickard, punitive damages currently under the common law, retaliatory discharge for whistleblowing, punitive damages are recognized common law for this type of case. Basically, the full panoply of tort damages, which would include punitive damages. Of course, we do have statutes. NRS 42.005 is a statute that governs punitive damages, but punitive damages are recognized in these types of retaliation cases at this point. So I would not see it as an expansion, no.
All right, I'm looking at 007, and I thought that was limited to certain cases. Maybe I mean, you're the expert in this, so I'll defer that point. All right, so even if it's not, it says the provisions of NRS 4207 do not apply to an action brought pursuant to the section. So I'm interested in understanding, why would we put this in? We say punitive damages if appropriate according to 005, and then 007 does not apply, and yet 007 is the broad, 005 is limitations after the proceedings. So can you explain how those are different?
Sure. For the record, JP Kemp, Senator Pickard, the 42.005 is what identifies and defines punitive damages. NRS 42.007 is a statute that was passed, I think, primarily after the tailhook incident, which there was concern that employers were being held vicariously liable for punitive damages by the actions of their employees. And so that's what 42.007 addresses. And this is to make clear that that doesn't apply here. So the employer, because the employment relationship is between the employee and the employer. So when the employer fires the employee, it's the employer doing it. But it's to make clear that an employer couldn't come and say, oh, well, that wasn't really us. It was this rogue manager of ours, this other employee. So you can't get punitive damages against us. It's to make clear that when an employee gets fired, it is the employer doing it. And so it's just to make that clarification that statute would not come into play in a case like this.
All right, I appreciate that. I guess my last question then is going to be with sub B, reinstatement without loss of position. this is where we're really intruding into right to work. And so often my concern is this: we've got employees sometimes that are really difficult, and then they make a claim just to avoid being let go. Wouldn't this make it really hard for private businesses to discharge the difficult employee?
Assemblyman Torres, for the record. If I could just interject here. So I just want to make it abundantly clear that this piece of legislation is aimed at targeting bad actors, right? So this is not going to just impact your business who lets go of somebody because they have, proof that the individual maybe has been taking extended lunches or something like that. It doesn't prevent that, right? So this is really aimed at ensuring that workers feel comfortable and confident going up to their employers and addressing any unsafe working conditions. That's what the intent of this legislation is. And I want to make it abundantly clear too that this piece of legislation would still have to go the retaliation, what they could receive, they would still have to file a lawsuit, and a judge would have to determine that they should receive that. So it's not like, any employee can just come up with a frivolous lawsuit and get the punitive damages or past or future compensatory damages or these other damages that are listed within the piece of legislation. I think that the legislation is abundantly clear that it would only be for those bad actors that are acting in bad faith. And, when an employee comes forward and says, these working conditions are unsafe, this ladder is not working, and I'm still required to use it to go up two flights to a second story building, then that employee shouldn't be fired just because they went to their employer and said, this is the condition, this is what's going on. And the unfortunate reality is that we're seeing that in our communities, right? And so employees just don't feel confident that they can come forward and talk to their employers about these unsafe conditions, and that's not good for employers or employees. The employers don't want extended workers' compensation cases. Employees don't want to get hurt. And they want to be able to continue to do their job. And so this piece of legislation is to kind of help both of those parties navigate that space. And I'm sure that
I
James will have some additional remarks.
Yeah. Well, I think you've addressed the point well. I know we need to move on. I'm concerned about the flip side of that coin, and I agree with you.
Senator Pickard, can
Yes.
you do me a favor? Yeah, I think we've gone into a lot of depth right here. Do me a favor, if you can take the rest of the concerns offline with the sponsor, I appreciate that. And just for the record, I just need everybody to know where we are right now. There are people who have to move in and out of meetings to present. There are a number of committees that are trying to extend their time or move their time forward or whatever. And so in the spirit of fairness, what I'm trying to do is make sure those who chair committees, especially those afternoon committees that want a little bit of time to move up beyond or before 1 o'clock, I want to make sure that we give them a chance to do that. A lot of bills left to be heard. We have almost 1,000 bills that were submitted this session. And really where we are right now is a consequence of not having annual sessions. We only have 120 days to get stuff done every 2 years. So I'm going to ask committee members if you will limit your question and answers to 5 to 7 minutes. So pick your top 3, the things that you know are most important to get into the record, and that would include your question and your answer. And ask and get that answer. And that way we can make sure that anybody else on the committee who has a question or answer gets a chance to do that. I want to make sure we cover it. We get a chance to hear all the bills, and we get a chance to do work session on those that are remaining. And while I'm there, Senator Settlemeyer, I haven't forgotten you. While I'm there, just want to explain to people too that whenever we do a work session, generally it is not a rehearing, and we cross the line on the last bill and put it into another hearing. So anyone who has major concerns about Assembly Bill 45, please make sure that you get with the parties, either with the Commissioner or Mr. Wadhams, clear that up. And when we come back next week, when we bring it back next week, we will not have an extended discussion on the bill. We will do an up or down vote. So with that, Senator Settlemeyer, you have a question. Thank you.
Thank you, Madam Chair. I appreciate that. I'm looking at Section 1A. When it says reporting to the employer or to the appropriate external authority. And my concern there stems from an issue of safety. in that respect, if on my business or, somewhere else, if there is a safety issue or concern, I expect my employee to tell me immediately of that safety issue and concern because it affects the well-being of other employees and individuals. And the concept of saying they can just report it to the external authority, calling OSHA, could leave a known danger that could affect myself or someone else. And I find that rather problematic, why that isn't an and. I have no problem with them reporting it to OSHA, but it also needs to be reported to the employer so it can be remedied. If you could address that, and then I had an additional question beyond that, Madam Chair.
Thank you for the question, Senator Settlemeyer. Assemblywoman Torres, for the record, I completely agree. We want to encourage individuals to go and speak to their employee. And right now, there's no protections for good actors like yourself, for employees to just go report it to them. There's no protection, no whistleblower protection for them right now. In statute, we have none of that protection. However, there is already the protection for them to report it to the external authority. So we're codifying that, but that protection already exists. And that's so that we can encourage individuals to report to OSHA if they maybe feel uncomfortable talking to their employer, but they're still encouraged to talk to that regulatory agency. And I don't want to disempower employees from having that avenue if that's perhaps the place where they feel most comfortable. And quite honestly, I don't think he was able to make it to this particular meeting, but I've spoken with Abraham Kamel, who's a small business owner in Southern Nevada who works on providing OSHA training. And oftentimes he has individuals that go and speak to him about the issues because they don't know how to navigate those spaces. Maybe there's a language barrier or something else. So I know that that's an issue that exists right now. And I definitely agree with you. We want to encourage them to come to their employees. And that's why we need this, their employers, but that's why we need this legislation, because right now there's no protection for them to do so.
I appreciate that, but what I'm looking at is there's not an and there. Again, this would allow them to only report it to OSHA and not report it to the employer. And you have to report it to the employer so the employer can make it safe before someone gets injured. That's my concern. So please take a look at that, and maybe we can follow up offline because the chair wants to keep moving. The other aspect I have is once they say that the condition is unsafe about something, what if the employer doesn't consider it unsafe? Does that now create a cause of action? Because sometimes my daughter looks at things and says, "Dad, that's dangerous." And I sit there and go, "Yeah, that's just kind of the way we do things." When it pertains to, you're dealing with certain things with knives, branding, and things of that nature, there's some things that are just inherently dangerous.
So then, for the record, I'm going to go ahead and defer to James Kemp to give some clarification of that and perhaps respond to the other question as well.
Thank you, JP Kemp for the record. And Senator Settlemeyer, there are always, the world is not a place that's clearly in black and white, and there always will be gray areas. And but I think that, when you've got a table saw that's missing a safety guard, a lot of these things will be very obvious. And there are some things that may be more of a gray area. It's only where the employer basically retaliates and fires the person. I mean, the employer, does have the ability to, fix things and take the appropriate safety action. It's where they fire the person because they've raised the concern that's going to be the issue under the statutes, under this proposed statute. So, in terms, I hope that answers your question. That most times it will be very clear, but there will be gray areas. There just always are in the world, and those will have to be dealt with on a case-by-case basis. But I hope that answers your question.
Mr. Kemp, does the concept, though, of a disagreement between the employer and the employee on what is considered to be a safe condition, or also now OSHA, so the three people have different varying opinions, does that potentially raise a cause of action?
Not if the employer doesn't fire the employee or take some other action. JP Kemp for the record, Senator Settlemeyer, this is only for those instances of retaliation. So there could be disagreements, but if the employer doesn't take retaliatory action, it wouldn't. There wouldn't be a cause of action because this only applies to retaliation.
Okay, let me be more direct. So let's say that the employee comes 5 times continually saying that these are unsafe conditions, I'm not going to work under these conditions. OSHA says, no, they're actually safe, and they keep doing it, and you're an employer tired of this type of a situation, you let the person go. Does that not potentially raise a cause of action?
It potentially would. The question then, though, becomes under the statute whether or not this was the employee's good faith belief. And if a number of people have looked at it and said, no, this isn't a problem, then that calls into question whether or not the employee has a reasonable good faith belief. And so that would not, the employee wouldn't be covered by the protection here if they've not acted reasonably and not acted in good faith.
Okay. Thank you, Madam Chair.
Thank you. Additional questions, committee members?
Oh, she's mute.
Madam Chair, you punched your mute button.
How about this? So I was reading this morning, not a question, a comment. I'm reading this morning in the Army Times that the Criminal Investigation Division of the Army is going to move away from the current structure into a different type of structure. And it is based upon the very tragic and unfortunate incident that led to the death of one of the soldiers, one of the women soldiers there at Fort Hood. And it came about as a result of her being sexually harassed and mentioning this to her supervisor, direct supervisor, who did nothing and wanted to mention it to someone else, and was told, if you do that, you better make sure you have some proof. And she told family members and told some friends what was going on. Went back to the supervisor, the person who was responsible for her well-being and safety, and they did nothing. Eventually, another soldier, although he completed suicide before he was charged, the evidence showed that he was probably the one who affected her death. I will say this as someone who experienced sexual harassment in the military as a captain, and the sexual harassment came directly from my senior supervisor. It happened to me in Panama in 1986, and I never told anyone until 1995 when I was promoted to lieutenant colonel. I was deathly afraid of losing my career. So I look at this legislation and I can understand the concern that there would be some people who would take advantage of it, but most people that I know are so glad to have their job and like what they do, that there would only be a very, very, very few people who would go down the path of just making up stuff just so that they could bring an employer down. And I think there are ways that we can put safeguards into this bill that would happen, because we have to admit, although not everyone, there are still some people who like to prey on those who are vulnerable. And if you are in a position of power over someone who needs the job, and if you are not a scrupulous person, then there are opportunities to do that. So I look at this bill through the lens of my experience. There was no way that I could even tell somebody that a full bird colonel had just propositioned me. There was no way that I could even get off the island of Panama. There was nothing that I could do because he held my future in his hand. And if I said anything to anyone, I'm pretty sure I would not be able to say today that I was a retired veteran. So with that, is there anyone in the room? I'm sorry, Assemblywoman Torres, do you have any other presenters, or can we go now to support?
Thank you, Chair. I think at this time we can go to support.
Okay, is there anyone in the room who is there to support Assembly Bill 222?
Madam Chair, it doesn't look like it.
Okay, so broadcast, let's go to the phones. 15 minutes per segment, 2 minutes per individual, and ditto is still a very good answer. As a matter of fact, the more this hearing progresses, the better ditto looks.
Thank you, Chair. If you would like to testify in support of AB 222, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 741. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good morning, Chair and members of the committee. My name is Paul Catha, that's spelled C-A-T-H-A, and I'm representing the Culinary Union. And in interest of saving the committee's time, I will just say ditto. Thank you.
Thank you, caller. Again, if you've recently just joined us, we are currently in support of AB 222. If you would like to testify in support, please press star 9 now to take your place in the queue. Chair, you have no more callers in support at this time.
Let's go to opposition. Same parameters.
If you would like to testify in opposition of AB 222, please press star 9 now to take your place in the queue. Excuse me. Caller with the last 3 digits of 124. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good morning, Chair Spearman and members of the committee. For the record, Paul Morakian, M-O-R-A-D-K-H-A-N with the Vegas Chamber. I would like to thank the sponsor and the proponents of the bill meeting on several occasions with the Chamber and other stakeholders about AB 222. In regards to the bill, the Chamber does not have an issue with the intent to codify the 2 separate court cases. In fact, as you know, Nevada does have laws in place that provide specific whistleblower protections in NRS 618. While some progress has been made since the original version of the bill was introduced, and we appreciate those efforts, we are still working to come together on an additional amendment to the bill as it relates to Section 1 as it pertains to legal remedies, the scope of damages that can be awarded, and what the correct reporting mechanism into which state agency. Both sides have and are continuing to work on several conceptual amendments as it relates to Section 1. This is a complex issue, especially since it relates specifically to workplace safety, and we want to avoid any unintended consequences that might harm employers or employees. Since we have not yet come to an agreed upon language, we are still opposed at this time, but we'll continue to invest faith to continue to develop a compromise language to the bill. Thank you, Madam Chair and members of the committee.
Caller with the last 3 digits of 114. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Greetings, Chair and members of the committee. Amber Stidham, that's S-T-I-D-H-A-M, for the Henderson Chamber of Commerce. And respectfully, we also oppose the bill as written and last amended. Our prior opposition focused on 2 critical concerns, and that was within Sections 1 and 3. We do withdraw our opposition to Section 3 as the bill largely removed that piece. However, as it stands, as noted earlier, Section 1 it is our understanding that the federal law already provides robust protections against retaliatory employment practices aimed at whistleblowers. And also, as the digest notes, Nevada law also contains protections for employees that are terminated for reasons that violate public policy. As last amended, though, Section 1 now provides that an employee who is discharged, discriminated against, or suffers a, quote, adverse employment action is not only entitled to lost wages and reinstatement damages equal to lost wages, but now also past and future compensatory damages, punitive damages, all in addition to attorney's fees and costs already provided for in this bill. While we can appreciate the intent of the bill, and certainly our chamber does not support bad actors, we simply cannot support this measure due to the very real concern that we have about the overreaching punitive damages in the provisions that are outlined, and its potential impact to small employers who, in some cases, would be working to financially defend themselves from he said, she said scenarios when they do need protection from those falsified complaints. The other damages already provide a terminated whistleblower with adequate protections for discharged employees to regain lost money, their job, and attorney fees. This proposal will put small business owners in a difficult situation in rehiring hiring, and retention. And we are also very concerned that bills like these will discourage out-of-state investment and economic diversification, both of which are very critical in helping our state move forward. Thank you for your time.
Thank you, caller. Caller with the last three digits of 131. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Chair Spearman, members of the committee, my name is Connor Kane, CONNORCAIN, and I'm testifying in opposition to AB 222 on behalf of HCA. I'd like to first thank the sponsor for her willingness to work on this bill. There have been a number of interested parties, and I know that she's been trying very hard to make sure she receives everyone's input, which, as all of you know on the committee, is no easy task. However, we are opposed to AB 222 as it goes beyond codifying the Wiltse and Alum Supreme Court rulings, which is what we had understood the intent of the bill to be. As a result, we think it could have significant unintended consequences beyond just reporting illegal or unsafe activity. We thank you, Chair Spearman, for the chance to provide input and appreciate the opportunity to keep working on the bill with the sponsor. Thank you.
Thank you, caller. Caller with the last three digits of 969. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good morning, Chair Spearman and members of the Senate Committee on Commerce and Labor. My name is Brian Wachter, BRYAN, WACHTER. I'm the Senior Vice President of the Retail Association of Nevada. I would echo the comments from opposition that came before me, but I would also add in addition that we are gravely concerned that this bill, AB 222, moves beyond looking for bad actors and instead, given the amount of punitive and treble damages, would create a system in which businesses who are doing the right thing are encouraged to settle these types of lawsuits in order to not be able or have to defend them over a long period of time. We believe that because OSHA has set standards on what is termed safe and what is not safe, that is a more traditional and appropriate remedy versus what Mr. Kemp even defined as a gray area, in which an employee can determine that they find something unsafe that an employer may disagree with. And then later that employee could be terminated for an entirely different reason. And we are concerned that that action would lead to the filing of these types of lawsuits. We are encouraged that the sponsor is still working with those of us in the stakeholder group, and we hope to get to a place where AB 222 is not anti-business, but at the moment, considering how it is written, we do have to view it in such a manner. We urge you to vote no in the current iteration of the bill, and we look forward to keep working with the sponsor to find a path forward.
Thank you, caller. Caller with the last three digits of 139. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good morning, Chair Spearman and committee members and Assemblywoman Torres. Misty Grimmer, GRIMMER, with the Ferraro Group, representing the Nevada Resort Association. We are before you today in opposition to AB 222 with the hopes of being able to continue work with Assemblywoman Torres in finding a compromise. The Assemblywoman has had an open door, and we have been exchanging language back and forth with her and the other proponents and are still working towards a resolution. For the formal reporting of a workplace safety violation, a mechanism for filing, investigation by OSHA, and punishment of the employer if they retaliate against the employee already exists in NRS 618-445. To create an avenue for a less formal complaint process, we believe a mechanism could be added to the statutes using the structure and punishment framework already in place in NRS 613 in the miscellaneous provisions that would be considered unlawful unemployment practices. For example, in that section, employer access to employee social media accounts is addressed, prohibiting an employee from having to show up in person to prove they are sick, non-compete covenants, and various other miscellaneous provisions are in that section. It is possible we could work within that section to address the goals of AB 222. With respect to protecting an employee's ability to refuse to perform a task that violates a law or regulation, we believe this is already protected in case law, and we would not oppose adding clarity to that protection to NRS so long as the protections do not go beyond unlawful activity. Unfortunately, as this bill is currently drafted, it does go further and includes the ability for an employee to refuse a task because they think the task imposes a risk to themselves or others. We are uncomfortable with how broad that language is. For example, when the mask mandate is lifted, this could allow a person to still refuse to work next to a fellow employee if that employee is not wearing a mask because the person is worried about getting COVID. Finally, the penalty provisions in the current law go far beyond what we generally see in statute for unlawful employment practices. As drafted, this bill would allow recovery of future wages. I'm not entirely certain what that means or where the limits on what that would be. Additionally, the bill allows for the employee
Caller, your 2 minutes are up.
to recover. Thank you, Madam Chair. We are still in opposition and we hope that we can continue working with the bill sponsor. Thank you so much.
Thank you, caller. Caller with the last 3 digits of 40.
Thank you, Broadcast Center. Madam Chair, for the record, Randy Thompson, RANDI-THOMPSON, State Director for NFIB, and I will just say ditto to my business colleagues. Thank you.
Thank you, caller. Caller with the last 3 digits of 216. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Thank you, Chair Spearman and committee members. This is Brian Reeder, BRIAN-REEDER with Variety Public Affairs, speaking on behalf of the Nevada Contractors Association. First of all, we want to thank the bill sponsor for meeting with us. We had a good discussion about the bill this week, and we hope to keep working with the bill sponsor to remove our opposition. Unfortunately, we are opposed today, and for the reasons previously stated. But Madam Chair, if you don't mind, without sounding cliche, I want to say that we do take safety very seriously. The NCA celebrates working in a safe environment. They honor contractors for having a strong, robust safety and compliance record at their annual Contractor of the Year award ceremony. The NCA has a safety committee that meets on a regular basis to discuss best practices and methods that they see in the field to keep employees safe at all times. Many of our companies also have a full-time safety professional on staff and in the field walking job sites to ensure compliance with all safety standards and that employees are working safely. And we do all these things not out of concern for legal liability, but just to make sure that the men and women in our industry go home safe every night. So we would like to keep working with the bill sponsor to get to a place where we are not in opposition, but unfortunately today we are opposed. Thank you very much.
And broadcast, we have 3 minutes left, so we either have two people on the line who will not take more than a minute and a half, or one person, the last caller would be, if they take 2 minutes, that'll be the end of it.
Thank you, Chair. Caller with the last 3 digits of 620, please slowly spell and state your name for the record. You have 2 minutes and may begin.
Thank you, Chair, members of the committee. For the record, Mike Cathcart, representing the city of Henderson. That's Mike, M-I-K-E, Cathcart, C-A-T-H-C-A-R-T. Simply put, this bill turns the whistleblower law from a shield to protect employees from retaliation into a process to supersede an employer's disciplinary processes. In addition, this bill creates another issue by allowing punitive damages. Punitive damages against a government employee are not a common remedy in Nevada law. This creates a disincentive to discipline and hold accountable employees who have filed any complaint. Also, by accepting the applicability of NRS 42, which limits monetary awards against the government, this change to the law could prove problematic for local government budgets. Finally, we look forward to seeing future amendments and working further with the private sector community and the bill sponsor. Thank you.
Thank you, caller. Caller with the last 3 digits of 701, please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good morning, Madam Chair and members of the committee. Mindy Elliott, representing the Reno Sparks Chamber of Commerce. To respect the time, I will just say ditto to all of my peers, and we appreciate the opportunity to testify this morning. And we look forward to working with the bill sponsor on future amendments. Thank you.
Thank you, caller. Chair, you have no more callers in opposition at this time.
Thank you. Just in time. 15 minutes neutral, 2 minutes per individual. Thank you.
If you would like to testify neutral on AB 222, please press *9 now to take your place in the queue. Again, if you would like to testify neutral on AB 222, please press *9 now. Chair, you have no callers neutral at this time.
Okay, thank you. Assemblywoman Torres, do you have any closing statements?
Thank you, Chair. Assemblywoman Torres for the record, and I'll keep my closing statements pretty brief here today. I just want to thank the stakeholders for coming to the table so that we can address some of the issues in this piece of legislation. I'm committed to continuing to work with them so that we can kind of fine-tune some of the language that I know Ms. Misty Grimmer addressed today. I'm committed to ensuring that we continue to collaborate on future amendments to this piece of legislation. And like Senator Sotomayor said, I agree that employees should feel comfortable talking to their employers about unsafe working conditions. And the unfortunate reality is that there is no protection for employees to talk to their employers about unsafe working conditions right now. And so I think that this legislation is very much aimed at resolving that very issue, that I think that employers want to have those conversations with their employees, and we need to encourage that. We need to encourage employees to have those conversations to prevent any danger to the employee or the employer. And this doesn't exist right now, and so this legislation is aimed specifically at that. Additionally, I want to address some of the remarks made by the opposition today. Somebody stated that there perhaps was still opposition, or some opposition may remain to Section 3. I want to make abundantly clear that Section 3 was removed in the revised version of the piece of legislation on the Assembly side, so there should be no opposition to Section 3 because it's non-existent. Opposition stated claims that this would lead to frivolous lawsuits if opposed for other reasons. So perhaps they would let go of somebody for a different reason. Nonetheless, I just want to make it abundantly clear that courts know how to address legitimate firing if somebody was let go for a different reason. If there is a legitimate non-retaliatory reason, the employee wouldn't have a claim. And this legislation makes that pretty explicit. Employers use pretext to hide real motives, and the courts have ways to address this. AB 222 ensures that hardworking Nevadans have the ability to work in safe conditions, and I urge your support for AB 222. Thank you.
Thank you. And just before you leave, I wanted our LCB council to comment on the safety concerns. I think Senator Sotomayor brought up or made a statement that I guess looks to that distinction. His daughter said that's unsafe, and he said that's just the way we do it. So, Mr. King, can you address the safety concerns? I don't remember who it was, but someone mentioned working next to a person without a mask.
Thank you, Chair Spearman. For the record, Will Keene, Committee Counsel. Yes, first, as far as other protections go, there is a patchwork of other protections existing in law, both at the federal and state level. This bill brings together those protections. As has already been mentioned, the Whittlesey case provides protection for whistleblowers who report to an external authority, but not to their employer. Federal statutes also provide whistleblower protections, but only in very specialized cases, and they don't always apply to private employees. For example, the Sarbanes-Oxley Act has been determined to apply to private employees, but those are very specialized. And also, there is a provision in Chapter 618 about reporting workplace conditions and preventing the employee from being discriminated against because of that. That, once again, is narrow and specialized to Chapter 618 and does not have the same sort of remedies as in this bill. What this bill does is it brings together all of that and allows an employee to have one section that they could rely on for all those different types of reportings. As far as the refusing to engage in activity that they feel is unsafe, this statute does allow for that, but they have to reasonably and in good faith suspect that the condition would violate local, state, federal law or regulation. And it's certainly possible that somebody would not have a good idea about what is unsafe, but certainly after the appropriate authority has said that it's fine, that would undercut that employee's argument that they have a reasonable and good faith problem with what's going on. But to be clear, as far as safety conditions that are covered by the current statute in Chapter 618, there's already in that limited context the ability of an employee to file an action. It would be with DIR, not with NERC, but it would already allow an employee to proceed if they thought something was wrong, and if the employee was wrong, then the employee would not be protected. Thank you, Chair Spearman.
Thank you, sir. Are there any additional questions, committee members? Okay, I'm going to do a one minute recess and we'll be right back, okay? 1 minute recess. Okay, we're back. So we thank you, Assemblywoman Torres, for that presentation, and those of you who participated. We'll now officially close the hearing on Assembly Bill 222, and let's go to the work session on our last bill. And after this work session, Vice Chair, I'll need you to take over because I need to move to another meeting real quick. But let's do the work session on our last bill, Mr. Melgarejo.
Thank you, Madam Chair. Vice Chair Neal stepped out of the room for a second, but she is coming back if you want to wait for a minute or two.
Okay, we'll do another 1 minute recess. So I'll tell you what we'll do. Let's go on back and we'll hear our final bill. And Mr. Mayor, let's move the last work session to next week, and I hope that doesn't inconvenience those who have been waiting to hear it today. Um, So let's open the hearing. I believe our last bill is Assembly Bill 436. So why don't we open the hearing on 436? Mr. Hillaby, are you there and ready?
Thank you, Madam Chair. I am Michael Hillerby, for the record, representing the Nevada Optometric Association. I know the day has been long and the hour is late, so we'll quickly go through the bill. It is relatively short. Give a quick explanation of why we're here. Most of you know I see a number with glasses like myself, that you may have vision plan as part of as an add-on to your health insurance. Vision plans, like dental plans, provide sort of limited benefits, often prepaid. For example, when you go in to get your annual vision exam, you pay a set price, and every so often you get a discount on a new pair of glasses. In the United States, about 200 million people have vision plans as a part of their health care coverage. 2/3 of them are covered by just 2 different companies. What that has done is limited, to some extent, choices for consumers and the options, and also created a very difficult bargaining environment for the independent doctors of optometry in our state and other places. Dental plans have been regulated in this state since 1983 in Chapter 695D. Rather than try to do an entire chapter around vision plans, we look to streamline this and put some very basic protections for consumers and for providers here in Chapter 686A, which is Trade Practices and Frauds in Insurance. And I'll quickly go through Section 1 of the bill. Section 1, Sub 1, says an insurer shall not enter into a contract with a provider of vision care that conditions the rate of reimbursement on that provider of vision care prescribing materials, ophthalmic devices in which the insurer has an ownership interest. What we saw with one particular plan just last year was a proposal that would reduce the rate of reimbursement to the eye doctor, ophthalmologist, or optometrist for that ophthalmological exam, the medical portion of the exam, unless that provider prescribed lenses and frames that were owned by the insurance company. That was of tremendous concern to our members and what that meant in terms of patient choices and their ability to provide the best care that was in the interest of the patient. Subsection 2 says before entering into a contract, the insurer must provide the rates that they reimburse to the provider. Again, not something particularly difficult to do. Number 3 provides some important disclosures, we believe, for policyholders, that they need to provide that whether they have any ownership interest, again, in the ophthalmic devices, glasses, other things that the provider might prescribe or be a part of that insurance policy. Number 4 is a prohibition on advertising that you provide reimbursement for things in which you don't. So it's a somewhat complicated language, and I know there's an amendment that we consider friendly from Reagan Comas, who represents the National Association of Vision Care Plans, to change or that in line 23 to if, and I'll let her explain that because I know she's on the line as well. And that what subsection 4 does is provide that an insurer that does not provide reimbursement for the specific vision care shall not claim in an advertisement that that's available without a copay or additional deductible if in fact there's an additional fee charged. Subsection 5 provides definitions of provider of vision care and vision care. Subsection 2, 3, and 4 repeat the provisions of Section 1 in other portions of NRS 686A. Again, this is generally the trade practices and frauds in insurance. Section 5 repeats the provisions in NRS 695B, nonprofit corporations for hospital, medical, and dental service. Section 6 repeats the provisions in NRS 695C, health maintenance organizations. Section 7 does the same for prepaid limited health service organizations. And Section 8 and 9, NRS 287, covers insurance programs for public employees. So that is the summary of the bill. I would be happy to answer questions. And again, while our Members are very interested in the bill. We knew that because of the time today, we didn't have room for a lot of support testimony, so you may hear from some of them after the hearing, reaching out to you directly, but I'll be happy to answer any questions the committee may have.
Members, any questions? Senator Lang.
Hi, I'm wondering if you could have Reagan go over her amendment so we can think about that in the whole bill.
Absolutely. Madam Vice Chair, I'll let you direct the committee and your staff.
So, Ms. Comus, is she on? Is she on Zoom?
What is her? She's not on.
Oh, what's her?
Reagan Comus, C-O-M-I-S. I do not know the phone number digits.
So she is on the call, so we can have BPS call her last three numbers, which is 268.
Okay, so BPS, can you call the last three numbers of 268?
Yes, I can, Chair. Please stand by. She is the only caller I have on the line. Give me 1 second to connect you.
Okay.
And you are now connected, Chair. Vice Chair, I'm sorry.
Thank you. Ms. Comus, go ahead.
Thank you, Vice Chair. This is Reagan Comus with R&R Partners, representing the National Association of Vision Care Plans. And if you'd like, I was intending in neutral to explain our amendment, but Senator Lang, if you'd like me to do so now, I'm happy to do so.
So go ahead.
Thank you. So currently, under our plans, we are able to offer certain rebates on contact lenses and frames for going through providers that are in network. And so we just want to be able to continue to have the ability to advertise those benefits to our enrollees so they can make those decisions as to the providers that they would like to seek. It's the ability that we have to do currently, and we saw it as just a technical change, as we discussed with Mr. Hillaby and the proponents of the bill, to make sure that we are able to continue to advertise those benefits. Does that answer your question, Senator Lang?
So your amendment is, let me see if I have this right, because I'm trying to see how it fits in here, but it's to allow you to currently do the advertising that you do with your members.
That is correct, Senator Lang.
And then on that...
so we saw it as a technical change. Go ahead.
No, go ahead.
I would say our understanding was that the way that it came out of the assembly, we were not intending to prohibit us from being able to make advertisements if there is the ability for a discount to be done. If there is no discount offered, we agree with the proponents that we should not be able to advertise that there are. And so we're just trying to make sure that that clarification is there.
Okay, so one of the things I like about the bill is that on the advertising part, they have to disclose if it's going to cost an additional copay or an additional out-of-pocket expense. So did you say that, where is that again?
So,
So
Madam
that
Vice...
is still in the language in sub 4.
Oh, okay. So you're going to leave that in?
That would require us to still, yes, that would require us to make sure that in that advertisement, we make sure our enrollees are aware that there would be a copay or coinsurance.
Okay, and Mr. Hillebree, did I understand you correctly that you've accepted this amendment?
Senator Lang, thank you. Michael Hillerby. We believe that changing those two words "or that" to "if" makes it clear that it is a conditional statement and avoids any confusion.
Great, thank you.
Members, any additional questions? So, Senator Pickard, no? We're good?
I'm good with this one, Madam Chair. Thank you.
Okay, all right, so we will then go ahead and open up for support for AB 436. VPS, is anyone on the line, or was it just that single person?
Thank you, Vice Chair. She was a single person, but I can make the announcement just to see if she wants to support the bill,
Okay.
if you would like. If you would like to testify in support of AB 436, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of AB 436, please press star 9 now to take your place in the queue. Vice Chair, you have no callers in support at this time.
Okay, thank you for that. So we will move to opposition for AB 436.
If you would like to testify in opposition of AB 436, please press star 9 now to take your place in the queue. Chair, you have no callers in opposition at this time.
So we will go to neutral.
If you would like to testify neutral on AB 436, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 268, please slowly spell and state your name for the record. You have 2 minutes and may begin.
Thank you, Madam Vice Chair. Again, this is Reagan Comis with R&R Partners representing the National Association of Vision Care Plans. And as we stated, we appreciate Mr. Hillaby working with us to make this technical change and accepting our amendment. And so with that, we are in neutral. Thank you.
Vice Chair, you have no more callers neutral at this time.
Okay, thank you for that. Any closing comments?
Thank you all for your time.
All right, so we will go ahead and close the hearing on AB 436. Madam Chair, she's back, you're back. Well, that was the
I'm
quickest
back.
bill ever. What did you just go say, hey, and exit?
We should have done them first. I think Mr. Hillaby made that purposefully because there is another bill that we had an extended conversation on. So thank you. Real quick question. We had one more work session bill, I believe it was 437. Mr. Melgarejo, can you check to see if they are still available for questions in the event that there are questions from the committee? And I want to stress again, the work sessions are not a rehearing. They're simply an opportunity for us to ask specific questions that were not covered during the previous hearing or in any amendment. So we will not have an extended discussion on this bill, but if the people are, the proponents are still here, the agency is still here, then we will work session that bill.
Madam Chair, this is Cesar Melgarejo for the record. The proponents of this bill stated that they would not be able to attend today's meeting because of a important scheduling conflict. However, they sent their apologies to you for not being able to be present, but there were no amendments to this measure, and there was no opposition that has been approached to them.
Okay, so let's go on and work session this bill. That'll be one less we have to do next week, okay?
Thank you, Madam Chair. For the record, Cesar Melgarejo, Committee Policy Analyst. Assembly Bill 437 revises provisions relating to embalming. This bill is sponsored by the Assembly Committee on Commerce and Labor on behalf of the Sunset Subcommittee of the Legislative Commission. For the sake of time, I will just reiterate that there are no amendments to this measure.
Madam Chair, I would move a do pass.
Okay, we have a motion from Senator Lang. Do I have a second?
Second.
Second, is that Vice Chair Neal?
Yes, ma'am.
Okay, we have a motion and a second. Is there further discussion?
Madam Chair, Joe Hardy here.
Yes, sir.
I just want to make sure that we are all in agreement that the fellow or the attending physician and assistants, the assistants includes medical students, medical residents, and medical fellows, as we discussed earlier.
Thank you, sir. And I think without, I don't know that there were any amendments contrary to that. We had no amendments to the bill. Is that correct, Mr.
Correct.
Melgarejo?
You're correct, Madam Chair.
Okay, all right. Additional questions, comments? And with that, Madam Secretary, please do a roll call vote.
Senator Hardy,
Yes.
Senator Lang,
Yes.
Senator Neal,
Yes.
Senator Pickard,
Yes.
Senator Scheibel, Senator Settlemeyer, Chair Spearman.
Yes, let the record show that the motion passes unanimously. And Senator Hardy, would you take this as a floor statement, please?
Be honored. Thank you.
Thank you, sir. And with that, we'll move now to our last agenda item, public comment, broadcast. Do we have anyone on the phone lines?
Thank you, Chair. Your public line is currently open and working, and you have no callers at this time.
Let's give it just a couple more minutes.
Standing by. Thank you, Chair.
Okay, anyone sign on yet?
Chair, your public line is open and working, and you currently still have no callers at this time. Thank you.
Okay, so with that, we will adjourn the meeting. We may have a meeting on Monday, still trying to work through to see if there are some amendments for some of the bills that we still need to hear, and a couple of the items that could be work session. I hope to know that before 2 o'clock today, and as soon as I know that, I will make sure that we relay that to our committee manager and policy analyst so that we can get it posted and get members of the committee notified with any additional information that you may need to peruse over the weekend. Committee, questions or comments?
Madam Chair, will we be meeting an extra day next week like we did this week? And I know that there's no floor on Tuesday and Wednesday, so would we meet longer?
We're still trying to work that out. Thank you for the question, Senator Lang. And the thing that's driving us right now is we've got a couple of bills that are still in limbo, where people are still working, trying to work both sides. We've got some things that, some amendments that still haven't come in, and so it's a very fluid time. As soon as I am notified, or as soon as I need to make the call that we will hear the bill, either a work session of the bill, I will be sure to let you know. I know Wednesday we will have an extended meeting. Most of that will be for work session. So the bills that will be posted for work session, I would encourage all committee members to get with the sponsors, get with the proponents and the opponents, and if there are any detailed questions that you might have that you need answered, please make sure you get that done prior to the work session. And whatever the results are of the conversations you have with opponents and proponents, if they need to be added to the record, please make sure that you do so at that time. Work sessions, we will not have another rehearing like we did this morning on a previous bill. So whatever questions you have, whatever issues you have with either the bill or with the amendment, make sure that you get with the opponents or the proponents of the bill. I hope that I answered your question, Senator Lang. That's about as clear as I can be right now, because everything is still rather fluid.
It's all good.
Okay. Rest assured, by this time next week when we adjourn, all the bills, it is my intention that all the bills that we can hear, we will hear, and all the bills that we can work session, we will do so. Okay? Again, I will ask committee members that as we move into this last week, if you can please keep your questions and your answers to answer period to 5 minutes. Give us your most important question that you need the most important answer to. That will allow us an opportunity to hear more bills and get more people on the record. It will also give us an opportunity to make sure that whatever clarity needs to exist prior to closing the hearing on the bill, make sure that that is indeed fact. So with that, we will close, we will adjourn this meeting, And as soon as I am clear on what we can and cannot do next week because of waiting on agendas or waiting on people to get things worked out, I will make sure it's posted. We may not meet on Monday, but I will let you know as soon as I do. Okay? Thank you. And so with that, we are adjourned. Have a great weekend.